typically a judge will put you under oath, and a lot of times judges will ask questions first of the claimant. But I would say probably at least a third of the hearings that we do, the attorney will ask questions first. So category number one is general background information. And the judge will say, what's your address, phone number, date of birth, how old are you? Who do you live with? Category number two is going to be about your education, work, and any certificates or licenses related to work. Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. The other part of being a really good listener is do not interrupt, okay? If the judge is asking you a question like, how long can you sit before you do? 10 minutes, Your Honor. And you keep doing that over and over, you're not letting the judge complete the question or your lawyer, so you don't want to interrupt. The other thing about interrupting, and if you do it too much, some judges will think you're being rude. I've seen judges call claimants out on it in the middle of a hearing. Excuse me, you're being extremely rude. You're cutting me off. And that's the nice way they say it. I've seen them say it a little bit meaner. So you just don't want to kind of keep interrupting your lawyer or the judge in the hearing. Okay? So, and again, just don't be distracted if you're or if you're doing a Zoom or MS Teams hearing, you can make good eye contact that way with whoever you're talking to or whoever's asking questions. So rule number one, listen to the question. Rule number two, make sure you understand the question. If for any reason you don't understand the question, ask for clarification. Just say, Your Honor, and always address the judge as Your Honor. Your Honor, I'm sorry, I don't understand the question. Okay? If it's your lawyer, you can just say, Mr. Evans, I'm sorry, I don't understand the question. What's really important too is, and I think in day-to-day conversations that people have, they will tend to if they don't know the answer, sometimes they'll tend to guess, and maybe they don't even know they're guessing, but they're kind of filling in the blanks. It's really important to remember that when you testify in a Social Security hearing, you're testifying under oath, meaning you will literally be asked to raise your right hand and say, do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? And everything you say is being recorded. So if you start guessing and you guess wrong, then technically you're violating that oath. So one of the things you want to do is if you don't know the answer, you want to say, I don't know. And so, again, rule number two is understand the question. Rule number three, answer only the question asked. I think this it gets a little bit tricky because I think, and I talked earlier about doing criminal law, and, in those cases, this needs to be really tight and buttoned up. Social Security, it can be a little bit more loose, but still in the same kind of overall general principle. You don't want people to run on and on and on. Typically, and so what the rule is answer only the question asked. So if it's a yes or no question, simply say yes or no. Keep a 10-second rule sort of in the back of your head, is what I tell our clients. Generally, if you've talked for 10 seconds or more, it's likely you've talked too long. And this is one of those areas that people can practice, right? Like, so I don't, John, I don't know how often you've been into a coffee shop, but let me practice with you here. Okay. If someone walks up to you in a coffee shop, do you have your watch on? You have a watch or a phone or something?
Yes, I'm ready.
Okay. All right. You ready? Someone walks up to you in a coffee shop. Excuse me, sir. Do you know what time it is?
It is 10:28.
Okay. Perfect. Let's evaluate this. Let's break down the question. Excuse me, sir. Do you know what time it is? Is that a yes or no question? Or did I ask you for the time?
It is a yes or no question.
So you gave me more information than I asked.
Right.
In law school, in our trial practice class, 9 out of 10 of us got this wrong. So you haven't been to law school yet. So if they do this in your trial practice class, you'll now be prepared. So, excuse me, sir, do you know what time it is?
Yes.
Yes, I do. Yes, I do. So those are simple ways to practice. Now, 9 out of 10 of us are going to be thinking, who asked that question of you and you give us that answer, will think you're being a smart ass. Okay. So this is where in Social Security court, if judges, you don't want them to think you're a smart ass, but at the same time, you get the principle of practicing it. Right. So if you, and listen, your lawyer, the judge, they are professionals at asking questions. I mean, it's literally what they do all day for a living, ask questions. So part of me is like, well, if the judge isn't asking the right question and you're a professional at asking questions, I mean, that's a little bit on the judge. I literally answered the question you asked. Excuse me, sir, do you know what time it is? Yes, I do. Well, what time is it? Well, it's 10:30 a.m., right? So this is ways you can practice. You can practice with a family member or a friend, and they're asking you questions. Just decipher in the very beginning, is this a yes or no question? Is this a question that's asking for a very specific thing about time, right? And kind of the big picture is you don't want to be going, oh, yeah, it's 10:30 a.m., but, we're in Starbucks and are you having a good day? And da-da-da. You just don't want to keep going on and on and on, right? So there's the spirit of what's actually being asked too, and I get that. But to practice, start there, right? So, John, we're prepping you for law school as we speak. I have a sub rule. So those are the 3 rules to answering questions in court. Listen to the question, understand the question, and answer only the question asked. I have a kind of a rule generally too about that. Just take one question at a time. I think a lot of people, when they're under oath, they start getting a little bit caught up in their head. It's like, oh my God. And I call it living in the present, right? This is what we talk about, living in the moment versus worrying about the future or regretting the past, right? So it's a life advice lesson that my mentor gave to me, and just generally about life, but it also can apply in a hearing. If you're worried that you didn't or regret the answer you gave 10 minutes ago, or you're worried about where is this going with the questions, you are not focused on the question in front of you. So just take one question at a time. Now, if you need to clarify something, you can jump in probably at the end or somewhere along the way that's appropriate if there's a natural break to say, Your Honor, I need to clarify something that I said before. And that would be appropriate. But generally speaking, take one question at a time. Okay? I have a sub rule to the 3 questions, or to the 3 rules, to answering questions. And it's this: use words with a clear definition. John, at a hearing, many times, or at work, often, I'll ask questions about asking you to quantify something. Oh, how many hearings do we have in a month? Or how many clients called in? Or how many emails did you send out? And let me ask you this. If you were to ask me a question, how many hearings would you like to have in December? because I know you help schedule all our hearings with Social Security. And if I said, oh, I'd like a few, does that help you out? Right.
Not at all.
Right. So instead, from me, you would like a specific number or a range. So if I said, hey, look, and I'm just making this up, I want 10 hearings, then that tells you how many hearings I want. Or if I want 5 or 15 hearings, or if I say, 10 to 20 would be good, right? That actually gives you information. So often and you're going to be, the claimant will be asked to describe their life. How often do you go for a walk? How often do you go to the grocery store? How often do you see family members and friends? And the reason Social Security wants to know these questions, or the answer to these questions, is that they want to make sure that the way you're living your life is consistent with all the reasons you say you can't work. So if you're going in there and you're going to say, hey, look, I can walk 25 miles. I've been training for a marathon, which I think is like 24 miles. So I can run/walk 24 miles at a time. I've been training for the Portland Marathon. Well, clearly you're not living your life consistent if you have a disability that you say, I can't walk or I can't work due to my back, right? Well, you're training for a marathon. So there's stuff that feels inconsistent about that, okay? So one of the things we talk about to folks, to our clients, is stay away from words like sometimes, frequently, occasionally, rarely, right? Because what's rare to you, John, might be occasional to me, right? I rarely go out to dinner. And you might say, well, how often is that? And if I was to really put a number to it, I rarely go out to dinner. I only go out like once or twice a week. But you're like, oh, dude, that's a crazy amount. 1 to 2 times a week. That's a lot, So it's more perspective if you start using those words, rare, occasionally. But one thing we all understand are numbers. I go out to dinner 1 to 2 times a week. I go to the grocery store 1 to 2 times a week. Be specific. When you're at the grocery store, how long are you there for? Oh, I'm there for a while. Well, I'm hardly there at all. Versus I'm there for maybe 10 to 20 minutes, right? Oh, okay. Why so short a time? Because my legs start hurting. I need to sit down, or I need to go home or sit in the car. So there are ways to describe it that makes it crystal clear for the decision maker. If you're describing it in such a way where the decision maker gets to interpret or give the definitions to your words, and that decision maker is inclined to deny clients or claimants, you're likely going to lose, right? So you want to be very, very clear. So use words with a clear definition, okay? The general outline to a hearing, and I'll just walk through it, and people can go watch the video, but there are typically you could take the hearing and break it up into 6 categories. So, well, maybe 7. The first category, let me just say this. You could take the hearing or the testimony that claimants give. So this is not including cross-examination, opening statements, or closing statements. You could take the testimony and break it into 6 categories. So typically a judge will put you under oath, and a lot of times judges will ask questions first of the claimant. But I would say probably at least a third of the hearings that we do, the attorney will ask questions first. So category number 1 is general background information. And the judge will say, what's your address, phone number, date of birth, how old are you? Who do you live with? Category number 2 is going to be about your education, work, and any certificates or licenses related to work. So education, how far did you go in school? Formal school, not like I was educated on the streets. I've heard people say stuff like that. Past relevant work, all the work you've done in the last 5 years from the date of the hearing. It used to be 15, now it's 5. And then any certificates or licenses related to work. Category number 3 and 4 sort of go hand in hand. And it's really the why can't you work either physically or mentally, and then when I say physically, we're talking about what your body, what physical impairments keep you from working. And when I say mental, I'm talking about your mind, what mental impairments keep you from working. The 5th category is those questions we talked about a little bit earlier, like grocery store shopping or what do you do in a typical day? And it's activities of daily living, or ADLs for short. What do you do in a day? What are your hobbies? Are you a member of any groups or clubs? Do you hang out with family members or friends? Do you go on vacations? Do you take care of anyone? You have, at this point, generally most claimants have filled out the adult function report form. We strongly encourage you to review that form because you've answered a lot of these questions, and hopefully you've answered them in great detail. I actually have another video, and I think it's about an hour long, where I walk people through on how to fill that form out. Some other questions they'll ask, especially if it's a physical impairment, is that they're going to want to know what is your physical residual functional capacity, meaning what's your ability to sit, stand, walk, and lift? How long can you sit? How long can you stand? How far can you walk? And how much weight can you lift without hurting yourself, right? And it all comes down to the judge trying to figure out, can you work? Can you work? So those are generally kind of the rules and the things to know in preparing your testimony, okay? Now, as you know, we give clients homework, right? And in that, we ask them, because especially if you're by phone, you're allowed to have notes in there to refresh your memory. Now, talk to your lawyer if you're represented. Some lawyers don't want their clients to have notes in front of them. They want to show the judge how difficult it is maybe for you to testify, which is fine. Everyone has their own opinion on things to use to refresh your client's memory. I think it's important to get the information out verbally. I also think you can ask the judge, hey, judge, I had to write down notes to help me with today's testimony. Is it okay if I look at it? So you're kind of doing a bit of both. You're letting the judge know that you need help, but now you have notes there. Because at the beginning of the hearing, John, the judge will say, you need to be alone in the room. You can't have anyone in there. So you can't have someone like a significant other or family member or friend kind of telling you what to answer, because then you have violated the judge's trust, because at the beginning of every hearing, it's almost like a script. Are you alone in the room? Right? And so that's really important. So the number one piece of homework we give is the first homework assignment is literally writing out the answer to the question, why can't you work?